This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. In addition to being one of the busiest courts in New York City, Landlord Tenant Court is probably the most maligned. Today we're going to talk to the Honorable Pierre Turner, a New York City Housing Court judge, and Gerald Colston, a real estate attorney who is the in-house counsel for a Bronx-based realty group, and find out what it's like to be in the trenches on a day-to-day basis. Hello, Judge Turner.
How are you?
Hello, Jerry.
How are you, Alan?
Judge Turner, tell us, what does your court do, and who does it represent?
Well, the court doesn't represent anyone. The court tries to administer quote-unquote justice.
Okay, that we all know.
Right.
But what is your court, the housing court? Who comes before you? What goes on in your court on a day-to-day basis?
Well, we get cases involving tenants who are behind in their rent. We get cases involving holdovers where the landlord and the tenants are not getting along, nuisances, tenants are living in one apartment while having another apartment that's rent stabilized, repairs are coming before us from tenants claiming the landlords are not doing the repairs. Tenants are coming before us who realize they have rent but don't have money to pay for the apartment. So we get a whole host of problems on a regular basis. Any day, an average day, we get from 80 to 110 cases.
Per judge?
Per judge. In the Bronx, per judge.
Now, it's been said that for a landlord to evict a tenant is a very difficult process, even when the tenant doesn't pay rent. Do you find that to be?
I was quoted recently in the New York Times. I said to a New York Times reporter, in the Bronx, if you're evicted, you have to earn it.
I think the judge's comment is a very good one, because I think it's really true. I think the court, in its wisdom of trying to do justice, it becomes very difficult to ever reach that ultimate stage of eviction, which is a very rare occasion, as I see it from where I sit representing landlords.
Jerry, I know you represent a group with hundreds, if not thousands, of apartments throughout the Bronx. Now, if a tenant is not paying rent, how long, in your experience, does it take from the day you serve those papers until you get that tenant out?
Alan, in the optimum world, that is, if I start an action early March with limited court appearance, maybe one court appearance by the tenant, it could take up to 3 to 4 months before I could ever be at the position to evict that tenant.
And during those 3 to 4 months, the tenant doesn't pay rent?
That's correct. That's, by the way, one of the major cries of the real estate industry, which we are trying to have the legislature, not the court, really deal with, which is a problem of requiring tenants to make deposits of rent when cases take longer than the norm or can move cases along quicker.
Judge, do most tenants come to you without an attorney?
Most tenants,
and represent themselves?
Most tenants do.
Do you find that you have to bend over backwards to help them through the process?
Well, not quite. What happens in general is a tenant comes before you, and the tenant will essentially say, in the Bronx, welfare pays my rent. And we have to deal with that issue. And we explain to the tenants welfare doesn't sign leases, that the tenant is responsible. Then we try to assist them. We may send them to the DSS, Department of Social Services, liaison in the building, try to get them to a center, try to help them obtain the rent. But essentially, we just try to work with that problem. We're social workers, we're judges, and we deal with a whole host of issues before we get to legal issues. In many instances, it's not really a legal issue that confronts us.
Judge, what happens in the case that one of Jerry's clients bring a dispossession against somebody? They come in and say, Judge, you got to come to my apartment. The ceiling's falling down. The plumbing doesn't work. I have rats in the bedroom.
Well, in that case, then I may send an inspector out, if it's that bad. That's not how it usually comes to me. It usually comes to me with the question of repairs and not having money to pay the rent. The tenant doesn't really have money to pay the rent, and the tenant wants repairs. we have to find a way to obtain the rent through various social agencies, and at the same time see that the landlord does what he's supposed to do pursuant to law, and that's inspect and repair the premises as required by law.
What happens in the case where you have an elderly person who just, for whatever reasons, is behind in the rent and cannot pay the rent? Circumstances, illness, half a dozen different circumstances.
We bend over backwards. When we see someone who's elderly, someone who can't assist themselves, some kind of problem, mental problem, what have you, we have a sense that that's the problem, then yes, we'll go to legal aid, refer them to legal aid office where they can help the elderly. PSA, we try to get involved at that time.
PSA is what?
Protective services for
Right.
adults. But if they have a problem, if they're elderly, yes, we bend over backwards.
Jerry?
Alan, I think what's important is that I do want to recognize that Judge Turner, as the other housing court judges, have a massive calendar to deal with and have numerous problems to deal with. And it's not a black and white situation. I think the problems that landlords feel and some of the frustrations that they feel is tenants have learned common words. They've learned, I need a repair. Quite often they do, but quite often I find, after inspecting apartments myself, there are no repairs, or they never told anybody about repairs. The second thing is quite often tenants feel that they have that ability to turn to a court and say, welfare is going to pay my rent. This is where the frustration lies, because what ends up happening is that the process builds in time factors in order to process us through whether a tenant will or will not qualify. As I said before, this could take 3, 4, 5 months. Sometimes, as we're seeing more and more, and we're going to see more and more in the future with cutbacks in welfare, tenants get rejected. And what's ending up happening, not through the court's fault, but through the process, landlords end up losing 4, 5, 6 months' rent.
Judge, how do you respond to that?
It's true. What happens is that the judges are bound by principles of stare decisis. The prior cases and appellate term rulings. We're under a certain constraint, especially in the first department, the Bronx and Manhattan. The appellate term in that department tells us that if welfare is involved, we must provide time for welfare to make a decision. And we're under constraint. Many times, landlords will say the judges are being unfair, but the judges are simply bound by the principles of stare decisis. We must adhere to appellate rulings.
Well, Alan, can I just interject? I agree that
Right.
the court does have to recognize that, but I think one of the problems is that in trying to bend to those problems of trying to get welfare for a tenant, we end up having a landlord suffer because of the fact that we build into the system delays of the way an L&T case works in non-payment. As Your Honor can tell you, is that we start an action, appears before the court, we discuss an item of repairs, and we enter into what's called a stipulation of settlement. This gives the tenant 3, 4 weeks to get the rent. What happens at that point in time is that if the tenant doesn't have the rent, either by the tenant's lack of doing anything with welfare or welfare's inability to process the claim, the landlord then has to make a motion, restores the case back to the calendar. Then the court gives the tenant additional time and a stay of a final judgment. What ends up happening is, and we're going to ultimately lead to where I want to get to, is that, yes, we must recognize the need to turn to welfare agencies, but we have to try to limit those time periods to deal with the real world.
Judge, is there a limit to the amount of time, or can it go on month after month?
It can literally go on month after month, depending what's going on. I had a case today, a 1993 case.
93, we're in 95.
Protective Services was involved. Department of Social Services was involved. The woman had a lot of problems with her children. The children were abusing her. She was in and out of hospitals. There was a whole host of problems in that one particular case. And granted, the landlord in many instances is suffering. But in that case, there were interim payments by DSS, $1,000 here, $2,000 there. Finally, today, we didn't put it to rest, but what we did, we have a decision an interim decision. They've guaranteed me they'll give me a decision, yay or nay, in 10 days. And I explained to the tenant, in 10 days, you're either going to have an approval from DSS or you're going to have to vacate the premises.
Judge, if I gave you the power of the legislature, I know you've been in that court for years, and you handle hundreds of cases a week, and your fellow judges handle hundreds of cases a week. Is there any way to hasten the process, to make it quicker?
In the real world, I'm not so sure. What you're doing now, in the past, when I first came to the Bronx, we have some great ladies working in the liaison office right now, for instance, in the DSS liaison. When I first came, there were 3 ladies working. Miss Carlson, Miss Cartledge, excuse me, Miss Austin, Miss Richardson. Now we have 2. They have a ridiculous
Are you
caseload.
computerized?
They're not, well, no, we're not computerized. Well, yes, the courts are computerized. We're not computerized in terms of the court being able to find out what's going on with DSS. I can't input something into a DSS computer.
Alan,
Jerry?
if I can jump in on this issue of the welfare situation, one of the things that our industry is really lobbying strongly and urging is that we have to understand the background. Social services creates in the mind of all that they should have a shelter allowance for a particular tenant so that they can have adequate housing. What happens is the tenants receive the money directly. What happens is the tenants have a problem quite often because of other restraints of mismanaging that money. What ends up happening at that point is that the tenant doesn't have enough money to pay rent. One of the suggestions that we have been making all along is that all welfare checks go directly to the owners, because by those owners receiving the rents directly, the tenants then avoid their own problem of mismanagement of funds, and therefore some of these problems might be limited, and we might not have to look for what we call bailout situations.
Judge, let's take some examples. Can a group of tenants say, you know, this building is miserable. It's just a horror to live in. Let's not pay rent anymore. Can they do that?
Oh, sure they can do that.
And that's
Then
a
they'll
rent
come
strike.
They'll come to court. In the Bronx, you don't see as many rent strikes as you see in Manhattan. But occasionally, you get one that comes before you. And what I do, for example, is we try to work out a program or work out something where we can get everything accomplished in one case.
Okay, now that's self-help on the part of the tenants. What about the landlord? The landlord's not getting rent. He knows the tenant can really pay the rent, and the tenant's just abusing everything. Can the landlord go and just change the locks on the door?
Well, tenant, no.
Landlord.
Not with a tenant. He can't. Not to a tenant.
What happens
to a
if he does?
licensee
What
or a
happens if
squatter.
the tenant goes to work and the landlord comes in with his people, moves
I can
out the
jump in on
furniture?
that.
The tenant will bring a
and
lockout proceeding in housing court.
What happens?
They'll bring a lockout proceeding.
And?
We come into court. We find out. We take testimony from the
But
tenant.
the tenant didn't pay the rent. There's no question
No,
about
but he's
that.
still a tenant. The landlord must bring a proceeding in housing court.
What if he doesn't in self-help? What happens?
It's not allowed.
I
Self-help
understand
is
it's not allowed, but he does it anyway.
We restore the tenant to possession.
And the landlord gets sued for wrongful eviction. And by
Outside
the
of
way,
housing
and
court.
by the way, that's a rightful thing. I mean, landlords should not be permitted to indiscriminately, without process. That's why we have a statute. The Real Property Actions and Proceedings Law is statutory. It permits landlords to bring actions allegedly quickly before the court, and they shouldn't be permitted to change locks.
Now, Judge, I know you're a housing court judge. You could sit anywhere in New York City. Is it different sitting in Manhattan than the Bronx?
In terms of the cases you receive, yes.
Talk about it.
Well, Manhattan, there's more money involved in the property in Manhattan.
Money always makes it
Landlords-
interesting, doesn't it?
It makes it more, a little feisty.
Right.
The landlords many times want rent-controlled apartments. They want them back. They want to put them on the open market and charge market rent, or at least rent-stabilized rent. So the landlords in Manhattan, if they get an inkling that the tenant's living someplace else, they'll fight for that apartment. They'll bring a holdover proceeding. The Bronx is simply, at this point in time, unless you're going into Riverdale or other middle-class neighborhoods in the Bronx, we are inundated with tenants who don't have money, who are basically
People's Court.
people's court, people who are poor and are really at the public dole. They need welfare to help them
Alan,
live and sustain
what the judge
themselves.
is saying is true, and I think one of the things that we have to look out going forward is what is going to happen in this housing court and to the landlords and to the tenants if all the proposals that are being suggested in Albany get passed and welfare payments are drastically cut. We have what's commonly known in the Bronx court, something called Jiggets. Yes. What is Jiggets? Jiggets was the name of a tenant who brought an action to seek additional shelter payments in that they felt they were inadequate, because shelter payments are limited by certain definitions. Jiggets has become a wonderful tool. It bails out tenants, it helps landlords, it helps the tenant, it keeps the tenant in possession so we don't have many homeless people. Well, the legislation right now that's being proposed is going to wipe Jiggets out or modify it drastically. That's our fear of what's going to happen at that point. Here we're going to have tenants who aren't paying their rent, who are probably using some of their shelter allowance for other things. This court that's overburdened now is going to be faced with a more severe problem.
Judge, with all deference to you, with all respect to you, I was in your court not so long ago, and the place was packed. It was hot. You couldn't use the restrooms. It looked like there was chaos going on. How do you respond to that?
We do the best we can with the situation. We have to get through the day, and miraculously, we get through every day with very few incidents.
But you take that court. Now, in the Bronx, you're in the basement of the courthouse.
That's correct.
And then you go less than 20 minutes away to Foley Square, the federal courthouse, where you walk in and you have a beautiful courtroom, mahogany paneling on the wall, soft chairs to sit in, and people, by their natural process, speak lower and have more respect for that system than the basement in the Bronx. How do you respond to that?
A different clientele. Foley Square, you're dealing with antitrust, corporate resolutions and mergers and acquisitions. You have a different clientele. I'm not justifying either system. I have no problems working with the people that come into the Bronx courthouse. They're people, they have heartbeats, they have blood, just like the ones that go into Foley Square.
However, the point I'm bringing out is the respect for the system. How can a litigant have respect for the system when the ceiling is peeling and falling down on them?
That's a good question, and it's miraculous. Because in the Bronx, what I find is that people in the Bronx, we have more of a collegial atmosphere in the Bronx than, for example, in Manhattan. In the Manhattan courts, which are better equipped, it seems to me, than the Bronx courts. I can't explain it, but the people in the Bronx do respect the courts, and basically, the vast majority of them, I don't understand it, but they come and they do give you deference, they do give you respect as a judge, and we basically have, as I said, very few incidents on a daily basis.
And we'll continue with this discussion about how it is in the trenches right after this break. You're watching Lawline. I'm Alan Schnorman, your host. Stay with us.
The air dances with the waters, which brings the rain that feeds the land, that is home to the animals. All life dances together.
In a world so connected, choosing one environmental cause can be hard. EarthShare is 40 environmental charities working together. You and your company can help by calling 1-800-MY-SHARE.
All life lives, or doesn't, together.
Excuse me, do you wear your safety belt?
Why, no, I don't wear my safety belt.
Thank you.
You could learn a lot from a dummy. Buckle your safety belt.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're talking about landlord-tenant court, the relationship between a landlord and his tenant and what each of them do together. We have Gerald Colston, a real estate lawyer, and Judge Pierre Turner from the Housing Court. Jerry, have you ever seen it where a tenant can actually use landlord-tenant court to harass a landlord?
Oh, absolutely.
How does that work?
Well, just by the simple factor of a tenant withholding rent, coming to the court, claiming that there are violations or repairs needed. As the Honor pointed out before, he's forced with a situation of potentially sending out inspectors to a building. Despite a landlord running the most perfect building in the world, there's that potential that there's always going to be things in a building that aren't perfectly up to code. And he's besieged with numerous violations when the issue before the court might not be any repairs in the tenant's apartment and might be just the simple payment of rent.
Well, to get to the bottom of it, for example, in Manhattan, when I started sitting, I would have cases and tenants would raise repair issues, and I would explain to them we can have an abatement hearing, we can try to settle these things, we can see that repairs are done, and sometimes the tenants would just not give up. I want this and I want that. And then once they realize we'll give you an abatement hearing, once we find out how much will be abated, the balance will be due as a judgment. You'll have 5 days to resolve it. The landlord will then do thus and thus and thus. Now, in most cases, most tenants would walk away from that and try to settle at a low figure because maybe repairs aren't really an issue. Possibly repairs are really an issue. Sometimes you just don't know. But in 1 week in Manhattan, I had 3 cases in a row where tenants argued, I have the money, the repairs are not going forward, I want a trial. And in 3 cases in a row, I awarded abatements and tenants wrote checks right there in the courtroom and paid the balance.
You heard it here on Law Line.
But it's never happened again since then. Okay?
And I think
but
that
the point I'm making, you have to have an open mind.
Question, Judge.
Let me just, Alan, finish. I'm sorry
Quickly.
to interrupt, but another way that this can happen with harassment is tenants have the right in the housing court to commence their own actions against owners.
That's
They
correct.
can bring what we call HP actions, and that then puts the landlord on the defensive, and once again we go through the situation with dealing with violations, and this could be just a subterfuge for the payment of rent.
Judge, in the city of New York, let's talk about the categories of tenants. I know we have rent control.
Yes.
We have rent-stabilized tenants. Is there anything else?
Well, you have free market tenants.
And
Tenants who are
free
paying-
markets.
Yes.
Okay. Now,
And you have co-op tenants, you have Section 8 tenants, you have tenants who in various federally subsidized programs.
now everybody wants to be a rent control tenant because
sure.
their rents are low. But what are the rules and regulations? What if I have an apartment uptown? I have an apartment downtown. I really live in Greenwich, Connecticut. I make $300,000 a year. Am I still entitled to that rent controlled apartment?
No, you're not.
Why not?
Well, the rent control and
I've
rent
been a citizen of
stabilized
New York.
apartments are for those who need apartments. There was a time when you had a need for apartments in New York post-war when there weren't that many apartments. Legislature saw it in their infinite wisdom to protect certain tenants and provide that if you had an apartment rent controlled or rent stabilized at least, you had a right to a renewal lease as long
Right.
as you live there.
Okay.
As long as you live there. A rent controlled person has a right to stay there as long as he lives there and uses it
And their
as his
children,
primary.
right?
That's true under Brashy and its progeny. If you have, you can succeed to the rights of your
And their
predecessor.
children's children.
And their children's children.
Back to be passed down
Ad
from generation
infinitum.
to
Ad
generation.
And I
infinitum.
think, Alan, that's one of the reasons why you hear so much discussion, because of this ability to pass on apartments that we're talking about potentially maybe eliminating rent control. Now, rent control should serve a purpose for those tenants who are either elderly, who have been in an apartment for a long time and are paying low rents. But rent control tenants for tenants who are paying $3,000 a month rent, tenants who are passing on apartments as one would pass on giant tickets, that's ridiculous.
Well, but tenants in New York, too, I think, need to have some protections. Otherwise, a lot of people couldn't afford to live here.
Let's go into that. If you're rent controlled or rent stabilized, if you make over a certain amount, you have to be decontrolled. What's that
Under the
amount?
new laws.
What's the
I believe it's a couple of hundred. I'm in the Bronx, $200,000,
Okay.
yes.
If you don't live in New York City, for how long? What if I have 2 residences? What do I have to show that I live in New York City?
Excuse me, I misunderstood you. You're a landlord, you're saying?
No, if I'm a tenant.
If you're a tenant.
And the landlord wants
Well,
to get me out of my rent-stabilized apartment. What
That's
does
a
he, Jerry? What does he
well,
have to show?
Well, that's a question of proof. What he has to establish is that his nexus is in New York, that he either votes here, his income taxes are here. He has to show that this is his primary residence. These are questions of fact that judges,
Combination
often
of factors.
have to hear.
Well, what if
it's not a black and white
well, what if
situation.
the person really has a place in Florida, and they have an apartment here? How long do they have to stay here?
Well, we all talk about a 6-month concept.
183 days,
Right.
181
But
days.
again, there's no, I think, as the judge would say,
It's
there's
not
no
fixed.
strict fixed rule. I mean, there are facts that vary in situations, as it rightfully should.
For example, Florida, you have a homestead exemption. Many people retire in Florida. Others in New York have homes in Florida, but they live here more than 6 months out of the year.
Right.
Okay? And I've had trials before me where landlord lawyers have argued, I can prove to you that they have a home in Florida and there's a homestead exemption. Well, there are appellate term cases that say that is not in and of itself grounds for granting the landlord possession. Because
Jerry-
a tenant may still have Manhattan as his nexus.
When the co-op market of Manhattan was hot as can be, the biggest thing was getting that tenant, getting the rent-controlled tenant, getting the rent-stabilized tenant out of that apartment, making it a free market apartment. What's happening now?
Well, clearly, we deal with the Bronx. My office.
You're a
is
Bronx
dealing-
lawyer.
I'm a
But you
Bronx
know
lawyer.
a lot of things. You live
I
in
sure
Manhattan,
do,
you know everything.
But the whole co-op world, as we know, is not the same world that it was in the late '80s and earlier than that, where getting an apartment was worth a tremendous amount of money. You know, people who were buying buildings and could vacate them and get vacancies and go in and sell them at free market rental at the height of the co-op market, there was a tremendous value. We don't see that anymore. There is still the ability to co-op. Some of my clients still, consider that. It's still an alternative. But as I said before, as the judge indicated, we don't see that in what we're dealing with on a daily basis.
Jerry, if you could improve the system, if you had the power of the legislature, if you had the governor, what would you do?
Alan, I have some very good suggestions. First, I would, as I indicated before, try to have some system of requiring tenants to deposit rents, either on their own or through some welfare situation. Two, I would be very careful in what's going on in the legislature with cutbacks. I think cutbacks are okay to avoid fraud, but what we have to do is make sure we have shelter allowances at market rents and permit direct payments. Third and utmost, which we haven't touched on yet, is the problem that landlords face in the housing court with what we call recurring orders to show cause. I think there must be some limitation so that owners are not in a situation that in one case you can have 7, 8 orders to show cause where a tenant doesn't appear or appears and gets an extension of time, doesn't have the money and keeps coming back.
Can you respond to that?
Yes, the appellate term recently ruled that orders to show causes should be decided upon by the housing court judge on an ad hoc basis.
What does that mean?
That it may be 9, maybe 10, but if there's a reason to grant the tenant more time, then the housing court judge has that discretion. Now, I can tell you...
It seems like if a tenant is savvy in this system, they can delay the process.
Certainly. But what happens also, again in the Bronx, in the Main, and including Mr. Colston, a lot of the lawyers are willing to work with the tenant because in many instances they're looking for all of the money to be paid. And this is where Jiggets comes in. Jiggets is a program, not only will it pay the rent to the tenant, to the landlord on behalf of the tenant in the future, but it pays all of the arrears that are owed the landlord. So this is why a lot of times these orders to show causes are continually coming in, and in many cases there's grief from landlords because they want the tenant out.
Judge, Jerry's talked about cutbacks. Now there's talking about cutbacks in welfare, there's talks about cutbacks throughout. If you had Governor Pataki looking in his living room right now at you, and some legislators, and Sheldon Silver, head of the Assembly, who watches the show, if he was out there, what would you tell him regarding these cutbacks?
That I would like to see programs continue for those that need it, but I would like to know a way that we could rid the system of those who are not really in need, because there are people out here right now in need who can't get assistance.
I think what the judge is saying
the money's running out.
Is so accurate. I mean, I think you recognize again that a Bronx real estate owner doesn't want to get that apartment because how much rent can you really get for a unit? We're interested in getting rent, we're interested in providing services. And I think the welfare problems are you have many people who are cheating, committing fraud, and those people are creating a system where there are the people who really need it are going to be deprived, and we're going to have chaos, I can tell you that, Alan.
I'm for the fingerprint system, by the way. I would like them to have fingerprints, the system utilized to find out who in fact is double dipping. Because again, I get people coming before me, people who work 25, 30 years, lost their job, can't get assisted. And people on welfare for 20 and 30 years who get assistance whenever they want.
Judge Turner, thank you very much for appearing on Law Line. Jerry Colston, thank you once more for coming on Law Line.
Thank you,
Jerry
Alan.
was one of our first guests 13 years ago. And as always, this is Alan Schnorman, and thank you for watching Law Line.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program is made possible by the New York law firm of Zollman and Schnorman, who specialize in the field of personal injury law, located at 63 Wall Street in New York City.